both houses of Congress, subject to approval by the affirmative vote of the majority of the particular house concerned. B, in the case of the executive departments, the heads of departments, offices, and agencies, insofar as their respective departments, offices, agencies are concerned, subject to the approval of the Secretary of Justice. C, in the case of the judicial department, the Chief Justice of the Supreme Court. And D, in the case of the Constitutional Commission, commissions and other constitutional offices, the respective chairman and members thereof. In the case of the office of the Ombudsman, the Ombudsman. The above officials shall likewise have the authority to render any opinion interpreting the provisions of the review and compliance procedures in the filing of SAL and disclosure of information. Following, it says, in the event said authorities determine that the statement is not properly filed or filled, they shall inform the reporting individual and direct him to take the necessary corrective action, meaning to say it can be corrected. And finally, it says, the individual to whom an opinion is rendered and any other individual involved in a similar factual situation and who after issuance of that opinion acts in good faith in accordance with it shall not be subject to any sanction provided in the code. What does this mean, Counsel for the Defense?
Well, to us, it is our humble opinion, Your Honor, that if there may have been discrepancies, inaccuracies, incompleteness in the returns, Your Honor, this can be remedied after a review of the SAL had been made. If it is not intentional, Your Honor, no criminal liability nor any administrative liability is incurred by the filing official, Your Honor. Furthermore, the law on the matter is very clear with respect to review and compliance procedure. And with the kind permission of this Honorable Court, may I be allowed to read the same, Your Honor? Section 10, I'm referring to the very law itself, Your Honor. The designated committees of both houses of Congress shall establish procedures for the review of statements to determine whether said statements which had been submitted on time are complete and are in proper form. In the event a determination is made that the statement is not so filed, the appropriate committee shall inform the reporting individual and to direct him to take the necessary corrective action.
What is my counsel, for the information of the court, what is the penalty of not complying with the required form?
As subject to corrective instructions that may be made by the committee investigating the issue, Your Honor.
There is no specific penalty?
No penalty. If it is not malicious, it was not intentional, and the committee determines that it is so, no criminal nor any administrative liability.
All right. Okay.
All right.
Mr. President, there are penalties under the law, but I can get to that later on. But can we hear from the prosecution, the point of the prosecution on this matter as well?
Well, actually, there is a case already decided by the Supreme Court, and that would be the case of Presidential Anti-Graft Commission versus Plato. In that particular case, this provision cited by the Defense Counsel was also the subject of issue. And according to the Supreme Court, if there has been omission or not a faithful or true declaration of the properties, the filer cannot avail of these provisions. In that particular case, the filer would be liable for perjury because the statement, insofar as the SALN is concerned, is made under oath, and there is a certification at the last portion that all the statements contained therein are true and correct.
All right. If it is a crime, is it a high crime?
Well, it is...
Is it a high crime?
No, insofar as high crime is concerned... No, Your Honor, it is not a high crime.
All right. You read the Constitution. Culpable violation of the Constitution, treason, bribery, graft and corruption, and other high crimes could be the basis for impeachment.
Yes, Your Honor.
All right. So that's the law.
Thank you, Your Honor.
All right.
Your Honor, please, may
Yes,
I be allowed
sir.
to make a short reply, Your Honor? The Plato case mentioned by my colleague, Your Honor, finds no applicability to the present situation. no analogy. It has no compelling force so as to be considered by this honorable. In there, Plato had been found to be liable on so many occasions already.
Yes, the gentleman from Iloilo.
Mr. President, this is a legal issue, and I thought that the agreement was that a legal memorandum be submitted. May we request that we now proceed with the trial and have the witnesses presented and these issues on what
So
constitutes.
let's finish this colloquy and proceed
Yes,
with
we
the...
proceed with the trial,
have
Mr.
gone-
President.
Sorry.
And
We have
therefore,
gone
Mr.
this far because there is a query posed by the honorable
Correct.
senator from Taguig, Your Honor.
The only reason why this chair asked the prosecution to classify perjury because in order to relate it to the grounds for impeachment and no other thing. So let's stop this argumentation. Let's proceed with the trial.
Thank you then, Your Honor.
So order.
Thank you, Your
And
Honor.
finally, Mr. President, may I just request both councils to submit the legal memorandum to the impeachment
Comply
court.
with the request of the gentleman from Batangas.
And one last final question to the prosecutor, Mr. President. Just a final
The
question.
gentleman from Makati and Bicol. Then after that,
Just-
the
yeah.
gentleman from Pampanga.
Yeah, just a final question, Mr. President. In relation to the cross-examination earlier, may I find out from the defense the nature of that cross-examination earlier? No? Because I did ask the question 2 or 3 days ago, if I'm not mistaken. Ilang properties na ba ang na-present ng prosecution insofar as the Article 2 is concerned? At sabi nila, meron pang 7 properties in Marikina. Because I've not seen the documents presented, no? But just for my understanding. And today, you did a cross-examination of the witness. Is it your position that in 1990, in effect, is that your position, that these properties have been sold already and therefore it is no longer found in the SAL? Is that what you're saying?
That's correct, Your Honor. Secondly, the property referred to by the Honorable Register of Deeds a while ago does not belong to the Chief Justice. It is registered in the name of the owner, the daughter, Your Honor, who is of legal age. And there could be no presumption that could arise under the situation unless fraud had been proven, Your Honor. Now, in these Marikina properties, if I may be allowed to go a little further in response to the query of the Honorable gentleman from Batangas, Your Honor, this property is one single parcel. It was subdivided into Marikina, into 7 parcels, Your Honor. It was sold already. There were 7 titles, Your Honor. But the buyer, we have the document of sale. We are ready to present it when our turn comes. But there was already payment of all the fees required by law. But the buyer did not register it. So it still appears in the name of...
And because
Justice
of that, let me just state for the record, and I will sit down and yield the floor to the gentleman from Makati. Nagtataka ako kahapon, sinasabi ninyo, that dahil hindi pa na-perfect yung transfer and therefore hindi kailangan ilagay sa SAL. Okay?
sige.
Now, in this case, baliktad naman yung argumento ninyo.
Hindi po. Yung,
No, because
sorry,
let me
sorry.
finish. Let me
My
finish.
apology.
Because in this case naman ngayon, sinasabi ninyo, hindi pa na-perfect to the buyer since 1990 and therefore, hindi pa dapat sa buyer yun, nasa sa inyo pa rin yun. Based on your arguments yesterday.
No, no comparison
Hindi pa consummated,
between that property and this property.
Yes.
The other property, there is a claim that there was already transfer of ownership. Constructively, Your Honor, we have authorities on the point that we should distinguish ownership from possession. If what was delivered is ownership, is only possession, not ownership, there is no legitimate transfer na. In this particular instance, Your Honor, not only possession had been transferred, even ownership. In fact, the real estate taxes are being paid by the buyer.
At any rate, all of this will be covered by the memorandum
Thank you, Mr. President.
of the parties when they submit their cases to this court.
We will comply, Your Honor, as suggested.
The gentleman from
Makati, and then Senator Pimentel, Mr. President.
Thank you, Mr. President. I think we should be happy that this discussion arose. We have been hearing the evidence presented back and forth. Now, what we have overlooked here is that we should determine whether the offenses or omissions committed by the respondent is or reaches the level of an impeachable offense. That is the criteria. Not every offense, not every omission is an impeachable offense. In other words, even a crime that may have been committed is not an impeachable offense. Now, we should not overlook that, and so the responsibility of the prosecution is to present evidence that would amount to an impeachable offense, and the defense must also diffuse it. Otherwise, if we are given, or the evidence presented here is just any kind of evidence, then I think it is not fair to the Senate, because our criteria is an impeachable offense. Remember that President Clinton was impeached. The U.S. House of Representatives impeached President Clinton. It was elevated to the Senate. When the Senate heard it, the Senate said it did not amount to an impeachable offense and cleared him. Now, that is the picture now. That is the situation now that we have to. Because otherwise we will be hearing all this. We want this finished, but give us evidence that has reached the level of an impeachable offense. As I keep on repeating, it's not just any offense. It must be of a higher bar, because we are removing a Chief Justice. This is not to say that it is like, for instance, an omission in this. Give us something to hang on to. So that's all I would like to say. Otherwise, we'll go astray in the course of the proceedings, and we have been listening to this. That's why I said I am thankful that this issue arose. Thank you, Mr. President.
Your Honor, Your Honor,
I'll recognize first.
Mr. President, thank you.
yes, sir.
Just clarificatory.
Gentleman from
Again, the order, sir, and Miss Oriental. To the Defense Counsel, how many documents, sir, did you have provisionally marked during the course of the cross-examination?
Of this particular witness,
Yes, of this
Your Honor?
particular witness, sir. Only one? How many? Only one?
Only two,
One or two?
only one, Your Honor.
One.
The other is sub-marking, Your Honor.
Yes, so one document provisionally marked, because you will have it properly identified by your own witness.
Right, Your
But
Honor.
even though it's a provisional marking, can we ask for a copy already so that we can anticipate your theory and we can appreciate the cross-examination? And yes, sir. And then that document, sir, is a deed of sale dated 1990, covering the 7 titles produced by this witness. Is that it?
No, Your Honor, he was only confronted with it because it is a document existing in our behalf, Your Honor.
Yes, sir. It's
But
a deed of sale, sir.
Yes, Your covering 7 parcels.
Covering the 7 parcels.
Emanating from one parcel only.
Yes, sir. Yes, sir. But covering the 7 titles produced by this witness. Okay. So, I want to ask this question to the witness. So, the 7 titles that you produced before this court are still subsisting in your book of titles. So, if someone were to ask for a copy, you would give these titles as still subsisting and valid titles?
Yes, Your Honor.
So, that means that 22 years have elapsed, and yet the 7 titles have not been transferred to the buyer named in that document. Is that
No.
So maybe we will just ask your witness why the buyer has